Okay, zoning board, we are live. We are recording. Phone lines are open. Go for it.
Thank you, Matt, and welcome everyone to the Town of East Hampton's Zoning Board of Appeals hearings for February 7th, 2023. We had three scheduled hearings. One has been canceled, and that is Notara Living Trust at 3 Northside Surfside Avenue in Montauk at Suffolk Tax Map number 300-51-2-6. That has been canceled. So then we're going to move to our second hearing, scheduled hearing this evening, and I'll read that into the record. The applicant is John and Nancy Magnan at 59 Osprey Road, Narragansett, at Suffolk Tax Map number 300-131-5-19. The size and location is 7,552 square feet at 59 Osprey Road, Montauk on the Sea, Section A, Lot number 72, Map number 2438, Narragansett. The description is to allow a front entry porch to remain on a parcel of land containing beach vegetation, a first-story deck expansion to remain within side yard line setbacks, and a second-story deck expansion to remain outside the town pyramid regulations. The relief sought is a natural resources special permit pursuant to 255-420 of the East Hampton Town Code, and 2 area variances pursuant to 255-850D are required. A variance of approximately 2.9 feet is needed from 255-1172D of the Town Code to allow the second-story deck on the east side of the residence to remain outside of the town's pyramid regulations, and 6.4 feet is needed from 255-1110, Table 3 of the Town Code, to allow the back deck to remain 8.6 feet from the western side yard lot property line where a 15-foot setback is required. The lot appears to fall under the 4/10 rule pursuant to 255-143D1, which would allow for the required side yard lot setback to be reduced to 10.24 feet, which would require a variance of only 1.64 feet for the back deck and any other relief necessary. The zoning district is B residence, AE flood zone, and the secret class is type 2. Council, do we have proper affidavit of service and posting?
We do. Pursuant to section 255-9-23 of the Town of East Hampton Code, we have both postings and certified mailings done on January 23rd, 2023, which is 10 days prior to this hearing.
Thank you. We'll have our report.
Yeah, I have to apologize. I left my photos in Riverhead. I was scrambling to get out of the office, but I can attest I was there on Sunday and it was properly posted. This is from the existing photos. It's a picture of the front of the house, and they've sort of created a sitting area. It's largely disturbed. Next. This is the side of the house going, it's the west going towards the north. Next. That's more of the side of the house. Oh, no, that's, yes, it's more of the side of the house. Facing south. Thank you. Directionally challenged. Next. And that's the other side of the house.
No.
No.
It's the same.
It's the same side? Oh, it's the south.
Yeah, it's on the west side there.
Oh, the west side. All right. Next. That's the deck. And leading up to the second floor deck. The bottom deck is the one that's at issue. Next. That's the second floor deck that stretches out over the first floor and creates the pyramid issue. Next. And that's the front of the house again.
Thank you. Joel? Joel, you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good evening, Chairman Deline and board members. Joel Halsey on behalf of Lighthouse Land Planning, representing the property owner, John Magnan. With regards to the relief sought, it was kind of a little bit long and wordy. And it almost appears like more than two variances are required in this. But at the end of the day, it's just a 2.9 foot variance and a 1.64 foot variance. I don't know what the variance is from 255-4-50D are referencing, but we're just looking for a 1.64 foot side yard variance for the deck on the west side of the house. Right here, it's 8.6 feet from the property line, and a second story deck overhang, just the railings, pierce the pyramid by 2.9 feet. With regards to the John Magnan application, it does request two minor variances for some decking that was reconstructed and expanded. The back deck is located 8.6 feet from the property line. The deck at one point was rotting and in need of repair. At the time the deck was repaired, it appears that a portion between the steps on the west side of the deck were filled in with 1.6 feet more of decking, basically squaring off the deck. I did submit a 1991 survey that was part of the CO. I don't know if you got a chance to review that. But if you look at that survey, the deck depicted on that survey was actually 10.2 feet from the property line at the time. I met with the surveyor to discuss how all of a sudden we had Morgan, are you trying to pull that up? Oh, how the house was essentially 13 feet from the property line at one time, and the deck was 10.2 feet from the property line. I guess at one point, the bearings were off in that area. So basically some boundary control issues were in the neighborhood and they needed to correct them with their future surveys. So you can see at one point, this stairway right here this area did conform to side yard setbacks. And if you squared it off, it would still conform to side yard setbacks. However, fast forward to 2023, 2022, the new survey shows that same area 8.6 feet from the property line and the corner of the house 11.2 feet from the property line. So, at one point when the deck was filled in, when the deck was repaired, it did conform, but now it doesn't. So it's kind of a boundary surveying issue. And again, it's beyond my realm of expertise. I'm not the surveyor, but that's it. It happened, and that's what it is now.
But it conformed at that time at the point where the staircase was established.
Exactly, when the staircase was
When you
established.
extend the deck on back, since the house is not parallel with the property line, that's when you get into trouble. Is that right?
Well, the deck didn't extend, it just extended between the two staircases here, which at one point, the staircase
Right.
did meet a 10.2 foot setback to the property line.
Right.
And, and so essentially the property lines basically just shifted about 1.8 feet or 1.6 feet somehow or another, boundaries, surveyors setting their boundaries back in in 1991, just slightly different today. So unfortunately it's affected a lot of properties in this area is what I'm hearing. The property owner believed that filling in this area was within the allowable setbacks and was not doing anything wrong except for not getting a building permit for a 40 square foot deck modification that was done when the deck was under repair. The property owner is very sorry for this and wishes that you grant him the requested variance. The relief would not impact the neighbor and poses no detriment to the environment. The second story deck was also reconstructed and was increased in width. The deck does meet the proper side yard setbacks, but unfortunately pierces the pyramid line. Please note, it is not the actual decking, but 2.9 feet of railing that extends in the pyramid line. And I did submit pictures of that railing, and as you could see the pictures earlier, it's very wide open and it allows for plenty of passage of air and light. And as the board knows, the pyramid law was adopted to prevent the obstruction of the passage of light and air onto neighboring properties. The amount of light and air the railing blocks is minor. With regards to the railings and further to the point of light and air, as you could witness in some of the pictures I submitted and the photos by member McGivern, the vegetation on that eastern side yard property line is tall, taller than the house. arborvitae's, and it just basically screens out. You can barely see the neighboring house through the trees. So worrying about light and air when you have that much vegetation on the property line, that the deck poses no detriment to light and air on the neighboring property when taken into consideration with that it being railing and the vegetation that's established on that eastern side yard property line. To that point, the railings have no negative effect on light and air as it pertains to the neighboring property. The last structure is the front entry porch that was enlarged. This was a recent project and done well after the west side deck and the second story deck expansions. The property owner had hired a contractor to do this and was told that they would handle the permitting. Unfortunately, this did not happen. And I understand the homeowners should understand the rules and regulations, but sometimes trust in people will hurt you in the end. To that point, the front deck does conform to town zoning and was constructed in an area that was most likely disturbed by driveway and human traffic. Had this deck been permitted properly, there's a good chance that it would have been out of NRSP jurisdiction. The reason is that likelihood that there was no protected vegetation with this minimal area on the property. Again, it was right next to the house. There was an area of driveway there. There's a lot of traffic in that area. Please note that the property owner has planted vegetation on their property, but between the deer and the lack of sun this property receives, they have had a tough time with vegetation. They are currently working on with the county and the town to get rebates in order to upgrade their sanitary system. Once the rebates come through for the county, the plan is to upgrade the sanitary system, and at that time they could do some vegetation within the disturbed areas once the system is installed. This is the only location where the system is being installed is basically the only location on the property that has adequate sunlight to establish vegetation. Thank you for taking time and reviewing this application. We do believe that this project meets the variance standards of the town code as outlined within my memo that I did submit last week. If the board has any questions, I'd be happy to answer them.
Would you just describe for me exactly where the
IA system
IA
is
system
going.
is to go?
The IA system is going to go all in this area.
So does that encompass the porch, or would the porch be disturbed by it? I guess
They
it's,
have to be removed to install part of the system, but the system does need to be, it will need to be at least 5 feet from the house. I don't believe that this is a full foundation on this house, so it would only have to be 5 feet from the house. So, and 2 feet. So it may disturb the existing deck.
So, but it's going to be in an area to the front of the house where there's already very little vegetation.
Exactly.
So it'll be that area that's largely at this point sand,
Sand and
if it's approved.
exactly.
Okay. And then the other vegetation you point out, which is, as you say, mature vegetation, some juniper in there, and cryptomeria on your east side, which is where the rail is, right?
Exactly.
So that rail is pretty much entirely the problem when it comes to this. It has nothing to do with the structure of the deck, because at 2.9, we're talking about 2'10", and the rail's probably 3. I didn't measure it, but I looked at it.
Exactly. Yes.
So it's basically shooting over the top of the deck.
yes.
And we're talking about the rail in its entirety.
The railing and the railing only.
And you're saying that we only have two variances to consider on this for us.
Yeah, correct.
That one and the variance for the squaring off behind the staircase.
Of the deck. Yes.
Just to clarify for me, on the total coverage, it's over on total coverage. Was the shed already removed?
The shed has been
Yeah.
removed. Yes.
Okay, because there is still a shed on the survey. So
No, there's no shed on the
it's a
survey.
shed near the steps on the east side in the back,
Existing
is that-
structure, that's a walkway. This right here. They're gonna remove.
where
the
it says shed. That, that's
says
gone.
shed.
That shed is gone?
Shed's gone.
Oh, okay, but it's still on the survey.
No.
What's that last revised?
July 4th, 2022.
Yeah, should have.
Yeah, we still see a shed.
Yeah, it says it. It says shed. The little black square thing near the railing that we
Yeah.
were talking about.
But that's an that's a legal shed. That shed to be removed was in the backyard over here.
Okay, that's what I want.
Oh,
Okay.
no, sorry.
And
I'm,
just removing that
I'm like, I'm
shed.
like, wow.
Brought it
I'm looking right at
into
the survey. Okay.
conformance? Okay.
No, that's the shed that's on the existing deck. The walkways and the gravel are to be removed to reduce the coverage.
The walk and those two things, removing all those round.
Exactly.
Okay, that will bring it into conformity. Correct. Thank you.
And that's on, excuse me, but that's running along the west side of the house.
the west side of the house and
The gravel and the pavers along the west side of the house we saw in the photo.
Exactly, and then this around the northeast corner, and then these planter boxes as well.
Perfect. Good timing.
Morgan? How are you, Morgan?
Morgan Slater from Planning Department.
You swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Right arm.
I do. The parcel is located on the north side of Osprey Road in the Montauk-on-Sea subdivision in Nappig. This area is comprised of smaller lots which contain duneland habitat and beach vegetation. This property is non-conforming to several aspects of the town code. The lot size of 7,552 square feet is less than half the required 20,000 square foot minimum for B residence zoning. The lot width of 64 feet is also non-conforming to the minimum lot width of 100 feet. As a result, this non-conforming lot width allows relief in the required side yard lot line setbacks through the 4/10 rule in the town code, which allows for a 10.24 foot side yard setback. A 2.9 foot pyramid variance is required to allow the railing of the second story deck expansion to remain, and a 1.64 foot side yard variance is required to allow an expansion of the back deck to remain 8.6 feet from the western property line, where 10.24 feet is allowed when utilizing the 4/10 rule. It is difficult to see when the back deck and second story deck extensions occurred when looking at the town's aerial photographs, so an exact time frame of their construction is unknown. The applicant must demonstrate compliance with the area variance standards of the town code in order to be eligible for the issuance of the requested variance. The board should consider the potential to set precedents in an area containing similarly constrained properties and the impact on neighboring properties. The applicant is also requesting an NRSP to allow the existing front porch to remain on a parcel once containing beach vegetation. The planning department performed a lot inspection for this parcel in December 2020, and it was noted on the 2016 survey submitted for that inspection that there was 100% clearing. Since the front entry deck appears to have been constructed between December 2020 and March 2021 based on aerial photographs, it can be concluded that the deck was built in an already disturbed area. It should be noted that a revegetation with beach grass and other indigenous dune vegetation was a condition of the administrative NRSP issued in February 1991 for the construction of the residence. A memo from the building department in October of 1991 stated that a revegetation of the property was satisfactory. So at one point, this parcel did have sufficient beach vegetation after the residence was constructed. The parcel also exceeds the maximum allowable total coverage, so the current survey proposes the removal of slate pavers, gravel, and a raised garden bed, which would reduce the coverage to 3,544 square feet, where 3,776 square feet is allowed. Since the current clearing is now the maximum allowed at 7,552 square feet, the planning department recommends that American beach grass is planted in the areas where the structures are being removed to better meet the NRSP standards and to maintain consistency with the conditions of the past approval on this property. Other than that, I can answer any questions about the application.
Have any questions?
I'm good. I don't.
I'm good. Thank you.
Thank you. So, back up. Is there anybody in the public that would like to address this application? Matt, anybody on the phone?
You have 0 callers. Thank you.
Thank you. So the clearing, the revegetation.
Correct.
Is the applicant at a minimum going to comply with the 1991?
At a minute, if we could find
Information?
it, the 1991 re-veg plan, we would definitely comply with that. It's going to be really tough. Well, I highly doubt the 1991 had, a re-veg along the side of here, because you're going to want to allow access up the side of your property. And there's not much room to do any kind of vegetation up the side without being able to access your property. And a lot of times we show clearing plans, the planning department prefers to see a 10 foot of clearing around a house to access around the house. So I would imagine the only area that there was any sort of vegetation would be in here and maybe up the property line, and maybe some in the back of the property. But if you go visit the property, this property is 100% shaded, pretty much this whole area around in here. So establishing any kind of vegetation is going to be really difficult, just because there is no sunlight on this property,
Except in the front.
except in the front.
And then there's some space along the back property line. There could be some revegetation
Okay.
takes place there. You could propose that as an effort here. And then I think if long-term, if we're thinking about this IA system going in the front, of course, you'll have to plant that entire area.
Yes, and that would area, once it's back covered. Unfortunately, that doesn't count towards clearing calculations. But usually, typically they would vegetate that.
Okay,
Okay,
Thank you.
thank you.
great, thank you. Good night, everybody.
Thank you.
In the matter of John and Nancy Magnum, 59 Osprey Road, Amagansett, Suffolk County Tax Number 300-131-05-19, and make a motion to close the hearing and the record.
I'll second it.
Oh, I
Okay.
concur.
I'll concur.
I concur as well. Thank you. Our next hearing this evening is East Hampton Planning Board at 30 Montauk Highway, Wayne-Scott, Suffolk Tax Map Number 300-192-2-66.2, 6.3, 6.4, 6.5, 6.6, 6.7. And the applicant again is the East Hampton Town Planning Board. The size and location is 70.51 acres at 30 Montauk Highway in Wayne-Scott. And the Suffolk tax map number I read off already. This description is pursuant to Town Code 255-830A3. The planning board seeks an interpretation as to whether a special permit is required for a planned industrial park for the Wayne-Scott Commercial Center preliminary subdivision application. The relief sought is an interpretation of the town code pursuant to section 255-830A3 in order to determine if the proposed project requires the granting of a special permit for a planned industrial park. Zoning district is C1, commercial industrial zone, X flood zone, and the secret class is type 2. And council, do we have proper affidavit of service and posting?
We do. Pursuant to section 255-9-23 of the Town of East Hampton Code, we do have service and posting on January 26, 2023, which is at least 10 days prior to this public hearing.
Thank you. And because this is an interpretation, we don't have a field report this evening.
That'd be correct.
I'm going to ask Eric Shantz to come up and introduce it, and then we're going to turn it over to Council David Egan to present his side. And I just want to make a statement that we are here this evening on a very narrow scope, and that is to determine whether there's a special permit necessary. We're not here to hear anything regarding that project in itself, and if anybody's here to comment on that, please, there's one tomorrow night you can go to, but we're here for that narrow scope. We're going to keep you to it, and I appreciate that. So Eric, you want to introduce?
Sure. Swear me in, or you want to swear me in?
Oh, yeah, Eric, you swear affirm to tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you.
So I'm Eric Shantz, the Assistant Planning Director. As the chairman said, this is a very narrow focus that the ZBA has before it. This is an interpretation request that was submitted by the planning board to the ZBA, basically just to determine if the project, the Wayne-Scott Commercial Center preliminary subdivision, requires the granting of a special permit for a planned industrial park. So what I'd like to do, if you excuse me away from the podium for a second, is just show you the location of the property and just give you a background on this project. So there are technical difficulties sorted out, hopefully. Okay. So this is the location of the property. It's roughly 70 acres in western Wayne-Scott. As a lot of people know, and as you can tell from this aerial photograph, this is a old sand pit that is reclaimed and closed. Basically, the preliminary subdivision application that is in front of the planning board is to subdivide this property into 50 lots. This is a little confusing in relation to the last visual. This is oriented 90 degrees north, would be to your right as you look at this map. So basically, as you can see here, it's a grid layout. It meets zoning in terms of density. The total number of lots is 50. The two lots on the southern end of the property contain a cement plant, an existing cement plant, and Southampton tile. Those are to remain. Basically, the remainder of the lots would be roughly 1 acre in size. So basically, this application was submitted in January of 2018 to the planning board. They've been reviewing it since then. Quickly into the process, the planning board made a positive declaration under SECRA in Chapter 128 of the Town Code, which identifies that basically the scale of the project, the nature of the project has a potential for significant adverse environmental impacts. Accordingly, under SECRA, a draft environmental impact statement was required to be prepared. The planning board has been reviewing that document for completeness for a number of years now. Very recently, it was deemed complete, which basically means that the application is ready to be scheduled for a public hearing and begin the public comment phase of SECRA. It doesn't mean that the planning board has made any decision on that application at this point. And, as the chairman also mentioned, there is a public hearing tomorrow at 3 p.m. at LTV Studios at 175 Industrial Road in Wayne-Scott to hear the main portion, of this project, which is the subdivision application. But again, going back to the matter that you're here to debate tonight or consider is whether or not this subdivision requires a special permit for a planned industrial park. So I prepared a memorandum.
Excuse
for the
me,
zoning
Eric.
board.
I'm
Yeah.
sorry. I'm going to clarify you on that. It's not 175, it's just 75.
Oh, I'm sorry. Thank you. That's important. All right. Sorry about that. So anyway, during the course of review, the issue came up of whether or not this subdivision also needs the special permit for a planned industrial park. So what we did was I made a point in the memorandum. The planning department does not take a stance on whether or not this project does. But what we wanted to do was aid your decision and give you some background information. So what we did was first of all, we gave you the definition of a planned industrial park, and then we gave you the special permit standards should it be determined if that applies. That's included in our memorandum. It's also included in some of the public comments that you've received. So I won't go through everything line by line. Basically, though, and I'm sure you're going to hear this tonight, there is a definition of a planned industrial park in the town code. It's a development of industrial land involving the subdivision of a large lot into 5 or more lots, each of which is at least 20,000 square feet in area. And I will point out that, this is a entirely zoned commercial industrial. It's industrial land. It is a subdivision involving more than 5 lots. Again, 50 lots is proposed. And generally speaking, most of the lots are around 40,000 square feet, with those two with the pre-existing uses being larger than that. So it clearly would seem to meet that definition. However, again, what you're being asked is whether or not that is required, whether or not this project requires the granting of that special permit. So the other information that we provided you, it's somewhat of an obvious question, is what is the precedent here? So we went back and we tried to find every commercial industrial subdivision that has been reviewed by the town. As you can imagine, there's not a lot of them, at least subdivisions that involve 5 or more lots. I was able to find a record of 3 individual industrial subdivisions. One was the Turnpike Commercial subdivision, which occurred in 1993. That is basically the lots that are on Plank Road near the Ross School. That I found no record in looking through the official file of any mention of the planned industrial park being required. That was an industrial subdivision that involved the creation of 8 lots. Smaller in area, it was about 13 acres total. Again, this is about 70. The other industrial subdivision that we found was the Good Friend Park Sections 1 and 2 subdivision. That is very close to Plank Road. That's on the other side of the larger Ross School property, and includes many of the properties that are actually part of the Ross School. So that's Good Friend Drive. That's a roughly 16-acre subdivision that occurred in 1983. It involved 15 lots. And again, in doing research, I saw no mention in that file of a planned industrial park either being mentioned as a possibility or being required. Again, with that previous subdivision I discussed in this one, there is no mention of it in the resolution of approval from the planning board. So basically, that resolution did not grant a special permit for a planned industrial park. The third industrial subdivision that we found was the Hardscrabble Commercial Industrial Subdivision. which is basically hard scrabble court, which is off of Route 114, roughly where the train trestle crosses 114 there. That was a 9-lot subdivision of about 13 and a half acres of land. The issue of a planned industrial park does come up in that file. It comes up basically towards the end of that process. There was a public comment that said that a planned industrial park special permit should be required for that project. The applicants, I'm basically just briefly summarizing this, and we did include this as an attachment, these documents and that whole file. The applicant came back, as you might expect, saying we don't need, we're not required to obtain a special permit for a planned industrial park. There was a planner memorandum. And again, this subdivision was in 1986. There was a planner memorandum that basically indicated that it was not required that they have that special permit. But basically, the end of that discussion, or the end of that process, was that the resolution that was adopted granting subdivision approval did not include the granting of a special permit. So basically, at least as far as we can tell, as far as that precedent goes, it doesn't seem that that's been required. Again, the most recent of those subdivisions was 1993, with one of them being in 1983, one of them being in 1986. Planned industrial park was a listed use at that time in the town code, but we weren't able to find that record. That, however, should not, preclude this board from asking other questions and finding other information. Again, those are also industrial subdivisions. They're not completely analogous to this situation. To my knowledge, just to give you an example, there were no pre-existing uses on the property of those 3 subdivisions. But basically, that's what we found when we were trying to address the obvious question of, has this been required before? Has this been part of an industrial subdivision? So basically, that's the information that we had provided to you. If you have any more questions about the larger project or about the memorandum that we prepared, I'm glad to answer them.
Were the uses, like Good Friend Drive, were the uses of the 15 lots known at the time?
I don't believe so.
And what about for the Ross School Plank Road one?
I don't think so with any of these. I would have to go back and look, though. I didn't look through the file with that in mind. So it's something I could easily look through and find out, but I don't think so from when I was looking at them, but I don't know that definitively.
Thank you.
I'd suggest I turn it over to Ms. Egan and then present it. If we have questions, we can pull you up. Counsel?
Thank
Good evening. My name is David Egan. I'm from the law firm of David Egan and Associates in Waynescott, and I represent the owners of the Waynescott Commercial Center. I appreciate Eric's thorough introduction. I filed last week a memorandum of law with the board, which I would encourage you to read. It sets forth what we believe is the correct legal analysis that leads you to, like we believe, is the obvious conclusion that at this juncture, for the various reasons was briefly mentioned, that we request that you render interpretation that we are not required to apply for a special permit at this time. There's a couple of key things I'd ask that you keep in mind throughout this process, because I think they're very important. One of them is the fact that a planned industrial use, as defined, what was read to you, the definition, is one of the listed industrial uses on the commercial use table. We are not introducing any new uses onto this property at this time. We have no plans. We don't know what will eventually happen with these lots. That's not unusual. To Ms. McGivern's question, I think the few examples of commercial industrial subdivisions that have occurred in this town, that's the case. And in fact, it takes a long time for these lots to be utilized. And our belief is this is going to be years or decades for this to fill out. Years, if not decades, for this to fill out. And I think we have precedent for that because for the Good Friend subdivision, which there was no uses for when it was created, a lot was just one of the remaining lots, and that was sold last year as a vacant lot. So it's not unusual to have the lots created and then the use be determined over time. And
Why would that not require? Why would that not require a special permit?
well, I can get into that, but
Okay.
because the short answer to that is that the planned industrial park use is not a use in the sense of a separate use. The planning memorandum that's included in the document that was given to you by Eric answers that question. It tells you what the purpose of that use in the code is. And what it is the opportunity for integration under certain circumstances. If you were introducing 5 or more listed industrial uses, not CI uses, I talk about that. CI uses a much broader term. There's scores of them, and it's divided into 4 categories: listed industrial, business, service, commercial, and what's non, what's the last word? I'm sorry, non-nuisance industrials. What that definition is what it does is it allows, based on the memorandum that was given to us, that Eric referred to in a hardscrabble memo that's in your record. It says what it was for. It allows, in the case if you were actually introducing more than 5 listed industrial uses onto a property, it gives you the chance for integration, and meaning that it allows you the opportunity to have a master site plan that allows you to integrate parking at the lot level, not at the creation of the lot level, at the lot level itself. When you're developing a lot, it allows you to do integration of parking. It allows you to do site landscaping and all that. It's all mentioned in there. It's very akin to the other use that's listed on there. If you look at, there's a business use called a multiple business complex. That's not a separate use that you need a permit for. That's something you apply for that allows you for the same integration. And there's not a lot of these have happened over the years because it requires a larger project, which our town doesn't have a lot of, obviously. But the most recent example I can think of that, of the multiple business concept, which this is very akin to, is Inlet Seafood. That's what they did. They were going to they had a number of lots. They were going to introduce a number of uses. And if you go out there, you can see when you pull in, they have one big parking lot. And that's the idea, to allow you to do one master site plan for the whole area. We're not introducing any new uses to this property at this time. We have no plans. We have nothing in the wings. This is all about going through the subdivision process and creating the lots. So we also want you to realize that when in the future, depending on how many lots we get, we don't know yet, any use that gets introduced to that lot is going to have to go through site plan and, if applicable, special permit and architectural review board status at that lot level. So I think that's very important to understand that there is no separate permit for a planned industrial park. It's not, it's just a tool that triggers the ability to integrate if you're introducing a number of similar industrial uses on the lot at one time. So I think that's vital to understand.
So then, in a sense, there's no, correct me if I'm wrong, there would be no parameters for saying there should be a central treatment plant or something like that.
Well, no.
At this point, there would be none,
No,
right? Because you don't know what's going
You
there.
just have lots. And that's what I wanted to get to. I think this whole idea, and I'm going to call it the special permit claim because it's just quicker to say. This whole special permit claim is the third thing I'd like you to keep in mind. Well, actually, before I get to that, the rule of ambiguity, okay, it's very important here in New York law. And the reason lawyers who represent applicants like it's probably the only presumption in law that's in a landowner's favor when it comes to land use. And it's very clear. What it says is when there's an ambiguity, because zoning in itself is degradation of common law rights, you have to resolve the ambiguity in favor of the landowner. That is basic New York law that any judge would be the first thing that they would cite when they looked at this. And it's applicable here because when the planning board referred this, when they made the resolution to do it, it was done on the basis that they found just that definition, when you read it in the code, to be ambiguous, as did the town attorney. And that's what triggered this referral. So that overriding rule of law or standard of review is something you need to keep in mind. It's not something, if it comes close or it's half and half, or it could be two meanings, you have to rule in front of the landowner. And that's basic 101 zoning law, which is going to be applicable in this form or any other form that we end up into. So with that going, I just like to quickly go through the reasons why we think that this is not applicable. The whole idea of the special permit claim really mixes two basic concepts in law. There's a black letter law difference between the subdivision process, which is a separate chapter of the town code. Remember, the town code is not one law. It's a collection of different statutes. It just happens to be indexed under the town code. Chapter 220 of that subdivision process is a separate code which you create lots. And in that process has all the standards that you need to meet to create the lots, okay? That's what we're doing right now. We're not operating under the zoning code. You don't operate under the zoning code until you're introducing new uses onto that lot or structures onto those lots. We're not doing that. So that's a very fundamental distinction that I assume, hopefully everyone knows, but it's very important to keep in mind because this claim kind of mishes it all together and says, well, if you're looking through a subdivision, oh yeah, you must be having a use at some point. Well, it's not true. We're only creating lots with the intended infrastructure that you are required to put in under the subdivision code, which is basically internal roads and drainage. It's the basic things that you put in. And that is all we're doing. We're not doing anything more than that. And this is hard enough. We're not introducing anything else to this property. I'd also like you to keep in mind that we don't believe that the development is defined in the zoning code, okay? It's very broadly defined. Basically, if you do anything, it's development. I understand that. That same definition is cross-referenced to the subdivision code. But that doesn't mean that development under a subdivision code is the same as development under the zoning code. There's different. The subdivision code, any development under that is really the creation of the lots, which is creating a map. It's installing the roads, drainage, some street trees, things that you're required to put in as part of the subdivision process. You don't do any lot level development there. There's none. The only lot level development you do is under the zoning code, when you would introduce a potential use under the code. You need a site plan for it, so you do all your site plan analysis, which is somewhat analogous to the process that you do when you're looking at an individual lot. You're deciding where the structures go. You're deciding where, all those issues, parking, all those type of issues. That's development. It's different term of development. So I don't think you can mash them together. I think it's a mistake to do that, and it's confusing. the idea of, and I'm glad, and I appreciate what Eric's done. I think the research that they did was absolutely on spot and answers all these questions. It's got to be persuasive to any board that the only commercial subdivisions that ever came before the planning board did not require this. So the precedent of that is binding. It shouldn't be binding, but it's persuasive. However, in this case, there's even more precedent, which may be binding. And you people are familiar with the idea that you are required to rule consistently with prior applications unless you have a good and rational reason not to do that. You guys deal with that concept, I think I know often. Well, it turns out that around 1996 and 2000, there was a subdivision application pending by the same applicant on the same property for 24 lots, which went through two versions of the DIS. And this issue was never, there was no requirement even discussed in that. So that should be telling. And the only reason that subdivision kind of application was ended was because it got caught up in that series of moratoriums that were around the comprehensive plan in 2006. So it kind of abandoned that process. But there's precedent on this, not only in general. The only precedent that this town has that says it doesn't apply, but on this lot in the same circumstances, the difference in number of lots, I think, I mean, I don't want to be a wise guy. I'm not being, wise here, but when it comes to the law and the processes that and the permits that you require, size doesn't matter. It doesn't matter if it's 13 acres or 50 acres or 70 acres. It's the same process. It's the same rules. It's the same analysis. So we'd ask you to keep that in mind. And again, I asked you to look at that 1986 hardscrabble planning memorandum because it's very instructive. It tells us, one, why that definition's in the use table. It's not a separate use, because if it's a separate use, it doesn't make any sense, because then you'd have to apply. And then if you wanted to go in and actually put a use on the property, you need a second special permit. I've been doing this for, I don't want to sound like an old man from the sea, but I've been doing it for over 2 decades with this code. And I've never heard of a situation where anyone would say you need 2 special permits for the same use. That's just illogical. I think it's important for the board to keep in mind that neither the planning department, like Eric said, we've been doing this for 5 years. We may probably end up doing it for another 5 the way we were going, but that's okay. But no one in the process, other than opponents to the application, have raised this issue. The planning department hasn't determined it. The town attorney hasn't determined it. It originated with one planning board member who's been a very vocal opponent of this throughout, which I won't get into. That's another issue. And it's being now pushed by the Super Law Group on behalf of the Friends of George Capon. It's not coming from the town, which I think you would understand, but it's highly unusual, because any application that I've ever been involved with, the first thing that I would expect and know what the planning department does is they will look at it and determine what uses are required and what permits are required. And that's never been determined by the town. I think that should be very persuasive to you. And also, I'd like to say it's really an illogical claim, because if you were required to apply for a special permit for a use that you're not introducing, then why is it only limited to a planned industrial park? I included the commercial use table in here. I don't know if you guys are familiar with it, but there's scores of commercial industrial uses on here. If you were required, we would, under the logic of this claim, you'd be required to apply for all these at this point, which is obviously ludicrous. And so I think that same logic It shows how faulty it is. You're basically we're being basically they're asking you to force us to apply for a special permit for use that we're not introducing. And the other thing I'd like you to, back on the hardscrabble case, it's very also instructive because it tells us that, let me make sure I get this right. I don't know. Okay, this is important. In the hardscrabble case, it was the same situations here. The group for the South Fork raised the notion that a special permit for industrial park was required in that case. They did so because they felt that it would be enhanced review of this more comprehensive review if you apply in the site plan, the special and the specific, the general and the specific site plan standards to the subdivision. What that memo tells us, and I've quoted these in my memo of law, it's very couple paragraphs, it's not extensive, is that that's a faulty goal. That the planning department stated in that case that the subdivision standards are sufficient enough to address all those issues, except for one, parking. But parking is not relevant in a subdivision. You don't do anything with parking. Parking is related to a use. You know, if you have a grocery store, you need so many spaces. You have an office, you need so many spaces. That's done at the lot level in the site plan process under the zoning code down the road. So basically, the whole idea that this has come up is that, and the discussions at the planning board proved this, that Member Parsons and the super law group believe that somehow applying the special permit standards to a subdivision is going to make it more difficult for us to get an approval. And that's really faulty because the planning department tells us that there was no need to do that because the issues about creation of lots and all the environmental impacts, we've been studying those under the subdivision code for 5 years now, and the CEQA process. You know, we're up to 28 or 2,900 page DIS, just chock full of original testing.
How much longer do you think you'll be?
Not much longer.
Okay.
But I think this is important for you to know. So when you put that all together, and when you apply the rule of ambiguity, it just seems apparent to us that we're not applying for anything other than a subdivision under the subdivision code. And that's all we should be asked to do. And it's not unusual, it's typical. And the only thing that's unprecedented and atypical is that the fact that this claim is being advanced again, and it's not a novel claim. The claim was already advanced under the same code back in the hardscrabble thing, and it was denied on the same basis that we're asking. So I ask you to consider seriously what we've written. The precedent, you know, it's in zoning, there's not that many novel concepts, as you know. I mean, you're dealing with the same concepts over and over, and this code's been in effect since, you know, the early 80s. So it wasn't like a light bulb went off in someone's head and they came up with a great idea to be a further obstacle to the application. This has already been issued. This issue has been dealt with, you know, years ago under the same code. Nothing's changed. The only thing that's different, and again, it can't jade any of this analysis. This is a big project. I get it. You know, it's 70 acres. You know, it's a piece of property a local family's owned since 1984, when they bought it from the DeGate family. And so at some point, they're moving ahead to do something with it. And that, whatever that thing is going to be determined in the subdivision process, not in the site plan or not in the special permit process at this point. So With that, I'd answer any questions that you have.
Any
I would be glad
questions?
to answer.
I don't really know.
Thank you.
Thank you.
Can I clarify something very?
Sure, sure.
I just want to, I'm again, not looking to get in between the various attorneys' arguments and stuff that you'll have presented to you here today. But just to clarify, just because there was one statement made that that you know, if a special permit, let's say for a planned industrial park was required first, that, you know, there would be, that there's not a situation where normally somebody would come, you know, need to get another special permit for the individual use on the lot. I just want to point out that if somebody was looking to develop one lot with more than 2 commercial uses, so, you know, you're permitted 2 uses on any one commercial or industrial lot as a matter of right. If you want 3 or more, you need a special permit for what's called a multiple business complex, or if it's industrial, a multiple industrial complex. But if some of those individual uses happen to be special permit uses themselves, you would also need to obtain the special permit from the planning board for those individual uses. So I just want to clarify that under the code, there is a situation where you would have somewhat of a, you know, overarching special permit for a development and then individual special permits that would be required. So I just want to clarify that.
Good evening. Thank you. My name is Reed Super. I'm an attorney here on behalf of Friends of Georgia Capon Foundation.
Okay.
Do you want to swear me in? Is
If you're an
not
attorney.
necessary? Okay. Thank you.
And I just asked you to be, you know, kind of, you've submitted documentation, just try to get to a point and not be exhaustive about it if you could.
Yeah, I mean, I'll try to be very brief. If I could have a little more than 3 minutes. I mean,
Sure.
what I'll do is I'll spend the few minutes that I was planning to spend, and then if I could address some of the things Mr. Egan said when he was referring to me. So, Mr. Deline and members of the board, the zoning code unquestionably requires the Wayne Scott Commercial Center to apply for, obtain, and comply with a special permit for a planned industrial park at this time, in connection with its application for subdivision approval before any building permits are applied for. The Wayne Scott Commercial Center is a planned industrial park because it meets the definition in the zoning code. The planning department just told you that it meets the definition and said the question was whether the permit is required or is essentially optional, but it does meet the definition because it's a development of industrial land involving the subdivision into more than 5 lots. The development that is presently proposed includes the internal paved roads, stormwater drainage systems, and the other infrastructure and utilities for the entire 70-acre park. That's all development as defined in the zoning code. Those are all structures and they all need building permits. The landowner argues that it could not fill out a special permit application at this time, and the planning board couldn't apply the general or specific standards because it's not yet known what all the uses will be on the 50 lots. But that's not correct. The special permit needed now is not for all of the lot-specific uses. Some of those uses may also need special permits in the future when they're sold or rented to ultimate end users. And that's what Mr. Shantz just got up to tell you, that sometimes there'll be a special permit for the whole area and then individual special permits for uses on it. The special permit is for the planned industrial park itself. The planned industrial park, and Mr. Egan said this himself in his memorandum of law, it is defined in the code as a listed industrial use, and it's also a special permit use. The 70-acre planned industrial park, that is a use, and then each lot may also have another use on it. The special permit is required now for the planned industrial park itself for its overall layout, its roads, its access, its drainage, and the other infrastructure, utilities, landscaping, buffers, and screens, wholly apart from the use on any particular lot. In our letter, we quoted the specific standards and safeguards in section 255-5-50, which requires the planning board to decide whether there's an overall plan with adequate and suitable designs for all of those aspects I just mentioned, the infrastructure and the roads, for the overall 70-acre industrial park. So that's what would be applied for now. That's what the planning board would apply, the infrastructure, the drainage, the roads. If no special permit application is required now, then the Wayne Scott Commercial Center will alone determine the location and the designs for the overall infrastructure plan, and the layout will apply for building permits to implement all of that without any of the safeguards of the special permit as set forth in the code. And it'll be too late to apply those standards later when lot-specific special permits are sought, because the overall layout and infrastructure will already have been constructed. So I was going to stop there, but if I could, just take a few more minutes and address some of the points that Mr. Egan just raised. Mr. Egan was talking about the definition of planned industrial park, and he was talking about uses, but you don't see the word use in there. It's a development of industrial land involving the subdivision. The use is the industrial park. Mr. Egan said this has never been required before. In particular, he pointed to the 1980s hard scrabble industrial park. If you look at the planning board's memo from 1986, it didn't analyze the question of whether a planned industrial park would be required. It came at it as whether it would be a good idea from planning purposes to go through that process or not. As far as we know, this board has never decided it. The planning board has never decided whether it's required, only whether they thought it might be a good idea or not from planning purposes. The town attorney has never decided it. So there's no precedent here. And when Mr. Egan said that the same property owner for the same lot applied for subdivision around 2000, that never went all the way through. He withdrew it. That was withdrawn. There was no determination ever made then as to whether a special permit was required. I'll wrap up in just a minute. The ambiguity, the rule of ambiguity that Mr. Egan cited to, first of all, this is very clear. There is no ambiguity. But if it were true that anything that came before you on the referral from another board would have to be resolved against the town, that would hamstring your ability to provide interpretations. The fact that somebody said it might be ambiguous doesn't make it ambiguous, and it doesn't mean that you have to, in every interpretation, rule for the landowner. You can apply the code as this board is empowered to do. See if there's anything else I want to make sure to address now. I think I'll just close with reiterating that the landowner has admitted that a planned industrial park is a listed industrial use, and it's a special permit use. And the reason why the special permit is required for that special permit use is in section 255-520, which says that all special permit uses must have a special permit before any building permits are issued and before the landowner commences, and there's a whole bunch of other terms that are like commence that follow it, before any action is taken to implement that use, before any building permits are issued. The use here is not what will happen on some of these lots. The industrial park is the use. It's the special permit use. It's the listed industrial use. And the special permit here must be applied for in connection with the subdivision and before any building permits are issued and any action is taken to implement the 70-acre park itself. And I'm happy to answer any of your questions.
Anybody have any questions?
I had one question. How do you answer Mr. Egan's claim that the subdivision process under Chapter 220 is adequate?
The subdivision process under 220 deals with subdivisions, and the zoning code, which this board interprets, says it refers to subdivisions. In the definition section, it says that a planned industrial park is the development of industrial land involving a subdivision. So a subdivision is applied for under 220, but under 255, any development, and the development is the roads and the infrastructure of industrial land involving a subdivision also needs a special permit. If there are 5 lots, if the lots are of the right size, if it's industrial land, and this is CI, which it is, and if there's any development, there is. So if that definition in 255 is met, then it's a parallel process to the 220 subdivision. Other questions?
Do you have any questions?
Thank you.
I do not.
Thank you very much.
Thank you.
Thank you.
I think we're going to go to the public. We'll come back to you, council, but I think we're going to go to the public first. And I'm gonna warn that we're only addressing this specific issue. So Debbie, come on up. You swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
And identify yourself, please.
Yeah, my name's
Okay.
Deborah Foster. I was part of the planning of the town as chair of the planning board when we were inundated by very large developments, both site plans, 1,000 motel units on Nappy, 600 car parking lots at the Grace Estate, 234 condominiums on the shoreline. And we figured that we needed to take a hard look. That's a lawyer term, at our regulations. They're insufficient. You wouldn't recognize this place if those applications went ahead. They're now all preserved. That's another story, but it's a good ending. We realized after, when I was chair of the planning board, we updated the comprehensive plan or the master plan. That is the key to any zoning. You have to have a blueprint from Waynesgate to Montauk of land use and uses on that land, or else you're going to lose in court. Because I was taken to court a couple of times. We won the town. It's interesting he mentioned a precedent. I was on the board for the Goodfen Park. We had not put in a special permit yet. We had changed some zoning, the zoning code. It mostly dealt with subdivisions because they were the ones that were coming in. Either Woods was going to be developed and they had to put a school in because the state required it. I mean, we were just getting out of control. But we realized sometimes that uses due to their location and the traffic that they might generate, or the any products that might leach into, or how they were going to contain leachate. So we figured, how can we do that? How can we say that because we're a sole source aquifer, the lens underneath us, and that's it for our drinking water, so let's not pollute it. We need to be very careful of what goes on in our shoreline, what's going to be near our ponds, so that we don't pollute with runoff or insufficient draining.
So if
So
I
we came
could
up with a
ask,
special permit. Go ahead.
just the scope we're within is why this is
Special use.
a special use.
I'm coming
That's
up
the
right now.
very narrow scope
All right,
that we
I'm
have.
going to read, first of all, in the code, which it's Article 5, Special Permit Standards, 255-510. What was the purpose? Because we have been using this. Mr. Regan is incorrect. We used it recently. Certain uses which are allowed under zoning, okay, are so likely to be significantly negatively affect their surroundings that they require review to assure compatibility with existing land use, in other words, what's around them, protect the community character, are they the right scale, and of course the natural environment and our water supply. Before being permitted to come into existence, the special permit mechanism can an increase, and other towns have done it, we didn't just make it up, can increase flexibility. It's actually, it should put everybody on the same page. Both neighbors and people that use Montauk Highway. It's their only entrance to our town.
Deb, we're going to
So-
ask you to wrap this up, please.
Is it equal?
No, there's a 3-minute, the public
Oh, but
comment is
they
3
get
minutes.
more than 3 minutes?
This is
I was planning board chair and I was
These are the
elected to the
applicant.
town
I
board.
get it. I
That's
get it,
not
but we
right,
have to
Roy.
move on, Deb. We have to move on. Okay, just give it one more minute.
Did a lot of work today. But I'm getting right to the issue of the special permit and why we went and did it. So it's a mechanism that can increase flexibility of uses, appropriate uses for local development, and makes it specific to each Hampton, and better make local officials not forced to avoid negative consequences. So I don't know if you've seen our 3-page uses chart. And we have an entire section on special permit. If the zoning board decides to get rid of it or try to modify it, it's going to take away the teeth that we need if there is a large-scale subdivision of land, and on that subdivision, there are different uses, not just houses, different uses. Like, just let me read these. So
We're addressing industrial, Debbie, I want you to keep focus here. We're dealing with industrial use. We're not dealing with other uses.
I'm going to read
We're-
what I'm reading.
Please wrap
what
this up.
It is. It's
Okay.
commercial industrial. It's a zone in the town. I can understand, this is planning board speak. It's a zone in the town that allows industrial development. So everyone else talked about it. I cued into it and made some note. Okay. So this use would allow, we noticed that without a special permit, there could be in this CI zone, an air terminal, animal husbandry.
Debbie, that's
bus
not,
terminal. You
Debbie,
can
I'm
read
gonna
this.
stop, I'm gonna stop
say-
you at this point because that's not within this purview of this evening. This is not what we're here to
tied
do.
together.
We're not here to decide or whether there could be a nuclear power plant there. We're
Don't
not
give
here
anybody any
tonight,
ideas.
right? So we're not there. We're here to discuss this specific issue.
The subdivision.
Wrap
and
this up, please. Just please wrap this up.
And I'm going to sit down in a minute. You gave these an extra minute to wrap up. And I'm upset about this. That there's only 3 minutes for me with the experience that I
Please
have.
wrap this up, please. We have to move on.
Yeah, but there's so many people here. Yeah, that's not right, Roy. Anyway, I can send the uses to you so you can read.
You
it.
can submit
It
that.
will
You can
throw
submit
them
that
out.
into the record.
And the point is, and there's case law on this, that once you create that subdivision with all these, there's 20 uses, exterminators, fireworks, you don't want those to come in. But the special permit says, if it's in a location that could hurt Georgia Pond or our water recharge area, or add to the traffic off-site. Hello? So that's part of what you're looking at. That you might not want to use it. And by the way, I want to say that the applicant has been very good about, he's coming to where we can go with this. And that is, he's looking at some uses that might harm the surrounding area and the public. And he's saying with a covenant, he's going to say, I'm not going to allow these uses. He still has uses left, but he's looking at the big ones here and just putting it in the covenants of approval. But once you create a subdivision, what goes on the land is germane. They are not separate. You can understand that.
Thank you. I appreciate it. Didn't mean to rush you up, but appreciate it. Thank you, Debbie. Who's next? Anybody? Do you affirm to tell the truth, the whole truth, and nothing but the truth?
I do. My name is Hersey Egginton. This is my wife, Deborah Egginton. We reside at 15 Hedges Lane, and I represent 7 homeowners on Hedges Lane, which is the road that runs north-south on the eastern boundary of the Waynescott Commercial Center. And we as homeowners feel that our neighborhood is threatened by the proposed development. We wrote to the planning board on November 14th. I don't know whether the letter was passed to you for your consideration, but we urge your board to interpret in favor of the need for a special permit to allow the planning board the greatest leverage possible over the design of such a major subdivision. And I'll just quote from a part of our letter. As abutters and neighbors of the site, we ask that the board require a special permit and apply the town code's special permit standards to protect our adjacent residential properties from incompatible commercial and industrial uses, as Ms. Foster referred to, specifically with regard to such issues as visibility, screening, scale, appearance, noise, traffic, circulation, light, and other adverse effects. We are the adjacent neighbors.
Thank you.
And just I would point out, because this probably wouldn't come up in any other forum, but on the plat that you saw, the buffer on the eastern boundary stops at the edge of our property. So we are literally abutters to this, whatever is going to happen. So a special permit would be
Thank you.
Useful.
Thank you.
Anybody else? Jane? Hi, Jane. Do you
Good
swear affirm to
evening.
tell the truth, the whole truth, and nothing but the truth?
Thank you. I do. And I'm only going to take a minute. That's all. As you know, I'm Jane Maring. I live in Ocean Lane in Amagansett. I submitted a letter to the board, which I'll refer you to. I'm not going to go into it, but I really just wanted to say 2 quick things. I heard Mr. Egan sort of talk about, being averse to the special permit because he said it would be an obstacle or it would be obstruction or it would make things
Thank you. Go ahead. Go ahead, Debbie. We're good.
So just to wrap up, there's sort of this assertion that I think he said, we don't know anything that we're going to do. We're not introducing uses. So I just want to refer you to the letter because I do go through many passages of the DEIS to show that there is a lot more there's a caveat that things will have to develop over time and they don't know exactly, but there's some very clear representation that the uses that are industrial in many cases are likely to happen. So I just wanted to flag that as part of the letter. That's all I have to say. Thank you so much.
Anybody else in the public? All right.
Phone.
Dave.
Do we have anybody on the phone?
Is there anybody on the phone, Matt?
Yes, there is. Let me let them in, please. It will be last four digits, 3472.
Hello, caller.
Thank you.
Please identify yourself.
My name is Bruce Solomon. I live at Hedges Lane in Wainscott.
And Bruce, you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Yes, good evening.
Go ahead. Hello?
Yes, hello.
Yeah, go
Can
ahead.
you hear me?
Yes, yes.
Yes, my name is Bruce Solomon. My name is Bruce Solomon. I live on 14 Hedges Lane.
Proceed.
I do. Yes,
Okay,
hi.
you have some.
I'm sorry?
Proceed.
Speak, please.
Tell us your position.
I am in a, thank you, I'm calling in from Up Island, and I am in full support of my neighbors. Yes. Yes. Hello.
Okay. Anything else?
I am in full support of my neighbors Hersey and Quincy Eggington, representing. I am attempting to speak. I am in. I will.
He's listening to the delay, and I think he's getting mixed up.
Yep. Okay. Can you hear me?
Yes, please continue to speak. We can hear you. Please continue.
Okay. All right. Thank you. I'm calling in from Up Island. Forgive me. I would like to be there in person to support my neighbors, Eggingtons, who have spoken already. I am in full support of a request for a special permit in the case of the development in the Wainscott Commercial Center.
Thank you.
Thank you.
All right. All right, Matt. Thank you. Is there anybody else?
Zero additional callers. Thank you.
David Egan for Wainscott Commercial Center. Just a couple quick responses to Mr. Reed Super. What he said to you is you need a building permit for the layout of the lots before you can, and the layout of lots, the utilities, the roads, and the other infrastructure. I agree with that, and that's exactly what you earn in the subdivision process. Those 4 subdivisions that were cited today got building permit after they got their subdivision approval, which preceded the, which concluded the planning department's determination that you meet the subdivision standards that are set forth in the subdivision code. Again, that's a separate process. He's collapsing the zoning code into that, and that's not how it's done. That's simply not how the code is constructed. And it's clear from the planning department's own research, it's not how it's been interpreted. So they're asking you to turn your back on 35 years or 40 years of precedent because I think it's a good idea. It doesn't work that way. It can't work that way. The second issue is you cannot in the zoning code automatically equate the term industrial land with the larger commercial industrial zoning category. That category includes scores of uses, and if you equate those, what you're doing is you're dismissing the whole concept of and structure of the commercial use table, which itself divides it into 4 different categories. And so I think the only fair and rational interpretation of the word industrial land in that zoning code is if you were introducing one of the listed industrial uses that are on the code, that are on the table that I've included for you. There's 20 some odd or whatever the number is. We're not doing that. We're not doing that. Again, I can't emphasize that point. It's so fundamental that you were being asked to apply for a permit for use that we're not introducing. It's illogical. So again, I ask you to consider the structure of and how the subdivision code operates independently of the zoning code. The zoning code comes into play when you are ready to introduce a use to the property. That's a very fundamental concept, but for you to accept this special permit claim, you're not recognizing that basic distinction, and that's a problem, because that's not how the code is constructed, nor how it has been interpreted. And I think that's why I would end it at that unless you have any questions.
Thank you.
And again, I ask you, please read the memo of law. I believe it's clearer than my
We will.
words. Thank you.
Okay.
Can I add something? I just want to make another clarification.
Not unless you're in a capacity of either side. If you're here on a capacity of either the town or the app or the in this case, we're not here to hear.
I don't have a problem with them talking. It's just obvious that you're not letting me talk. And I helped write this, and I know why it works, and we've used it in Good Friend Park and those subdivisions. We didn't have special permit. So
Just to talk in the mic.
record needs to be cleared up.
I'm actually going to speak to that somewhat.
Thank you.
Good.
Thank you.
Um, So I just want to clarify. So the 3 industrial subdivisions that I cited in the memorandum, I'm going to go through them chronologically, just quickly. So Good Friend Park, again, was approved in 1983. As you know, the comprehensive plan in 1984 brought about much of what our current code is. Prior to that, going all the way back, as far as I could tell, to the adoption of zoning in 57, the code had a very different construct. And what you had was you didn't have it organized the way that it is now. You'd have a listing of identifying different zoning districts, and then they just have a short list of uses that were permitted in that zoning district. So prior to 1984, in 1983, when Good Friend Park was approved, the code basically just said, CI zone, here's the uses you can do, service commercial, a list of industrial uses, planned industrial park. That also was not defined at that time. So fast forward a year, 1984, that's when, most of the modern code was created. Planned industrial park had a definition. It required a special permit in, this zoning district that this property is in CI. So just to go back to the subdivisions, Hardscrabble, which was the second one that I noted, which is the one that does have mention of a planned industrial park in it. That was 1986. So that was a few years after the code was changed to identify planned industrial park as a special permit use. And then Turnpike Commercial Center, which again is Plank Road, that development, that was 1993. And again, as I said earlier, and as is in my memorandum, there was no mention that I could find in that record of a planned industrial park. So it basically did not come up in the course of that one. But I just want to make that clarification that the code had a very different construct when the first one of those subdivisions was approved. So I just want to make that clear for the board.
Board, I'm going to ask you, we have a request to hear more from the public. What's your desire?
Yeah, I'm willing to allow it.
Yeah.
I'm willing to
Yeah.
allow it.
I am
Okay.
too.
Then we'll give you a couple more minutes. Excuse me? 2 more
The
minutes?
special
Minutes?
What?
2 minutes?
It's not counting now, right?
Now,
Yeah, fine.
Right now.
I just don't understand. This is so important. The planning board needs this for large CI subdivisions. Subdivisions themselves usually are houses, right? This is uh-oh, because we saw the uses in the old code. I started to read them, but I'll send them to you. That are just so inappropriate or need what they say is a hard look. The way to deal with that is, and he's starting to do it, take out something like fireworks and manufacture and storage of explosives, for example. I mean, they're right up against it. So it's not used for all subdivisions. It's just used for the ones that are near groundwater, are near Georgia. It's in, even the county says that it is in a special groundwater protection district. It abuts our groundwater protection district. In fact, Waynescott has pretty good water now. What if there's a leak with some of these things like an exterminator? That's what it's going after. And we need the reasons to say that it protects the health and the safety and the quality of life. It's where it's located, not to talk about the traffic. 600 cars an hour at max is worst case scenario. And he doesn't seem to be, all you have to do is say, we covenant that, just not appropriate there.
Thank you.
I can be on both sides.
All right, with that, thank you. Thank you. If there's nothing else, we'll move on. We'll make a motion. I'll make this motion as being this is my area. I'll make a motion in East Hampton Planning Board, v. 30 Montauk Highway in Wayne Scott, Suffolk Tax Map number 300-192-2-66.2, -6.3, -6.4, -6.5, 6.6, and 6.7 to close the public hearing and the public record.
I'll second it.
Concur.
Here's a return, just loaded.
We just closed it.
We just closed it.
I didn't hear anybody vote.
yeah,
all
we
voted.
did.
Yeah,
We just closed it.
We just closed the record.
I've never seen this.
We want to keep the record open a week.
But there is a planning board
This
hearing
board has
tomorrow
This
night.
board has policy. If somebody has something they can submit, but there's there's proper notice on the hearing. We're not gonna keep this ended.
That's not his fault. You just don't want to hear it. What we did want.
I don't think that assumption, Debbie, is absolutely correct at all. And I think you're wrong at that. So, okay, I think you're wrong at that.
Why don't we, do you want to let him file the letter?
Should we keep, what,
Then we have to keep the record open.
what's that?
Just a week.
Yeah, there's the hearing tomorrow, the public hearing.
Yeah, but that's not going to be incorporated into your guys'
No.
decision.
No.
It's separate and apart from this.
We can, which should we reopen the record?
You have to
You
reopen
have
it.
to reopen the record. Who is this? Who is for? From?
He's part of the person, town attorney that helped write it.
Does he have a name?
It's all right. Let's,
What is his
we're gonna
name?
reopen the
If we're gonna
record for
reopen it-
submissions only, for,
He wants to be able
Hold on,
to
hold on.
respond.
You're gonna open the record to a submission and I'm not gonna have a chance to read it or respond to it? This is opening up a whole other chapter, which is really not fair. This has been a properly noticed hearing. People showed up, we showed up. If you can call in, you can come in on Zoom. I mean, you have to be fair at some point. We've been working at this for 5 years. and we've done everything the right way. And, the fact that we're here is a
I
little
agree.
bit
I
troubling
happen
to
to
begin
think
with.
that if
It's not
this
your
is an important,
responsibility.
if this is an
But
important
honestly,
issue, there should have been an effort to been here tonight or to
Yeah.
submit something in advance for tonight. That's what I
I
think.
agree. Well, it's a letter that, you know how this works. It creates a record, it starts a whole other chain. And I don't think that's necessary. You've heard from.
Board, what's your?
Yeah, so given the comments that have just been made, I think that in the past, we have said that anything that gets submitted to us should have the ability to be reviewed by the public and be reviewed, let me finish, be reviewed by the people who have the greatest concern in this area. Something that we allow in now that does not have the opportunity to be reviewed is a problem because he will not be able to enter anything after that. We don't have the record open.
Talking to Mike.
No.
First of all, we have a closed hearing right now, so all
Yeah,
of this.
hold on.
Yeah, timeout. This
We
is a
shouldn't
closed
be-
hearing, so
this
if we're
is a
going to
closed hearing
continue, we're going
already.
to make a decision to open or just stay put.
Yeah.
Council, can we get some?
I think if you do leave leave the hearing open, you have to give council the opportunity to respond to
Correct.
whatever's
The
been
hearing,
written open. It's
absolutely.
only fair. I do see council's point of view and
If we open it, we have to. leave it
We're not
open.
talking about opening the hearing.
opening the record.
Yeah, first of all, you're supposed to be talking at the microphone,
But we
And,
have a
you know,
closed hearing.
but we didn't even, let's
Chairman,
make a
you did make a very
decision what
good
we're
point
doing
that
first.
people have 5 days prior to submit theirs. This was
Exactly.
properly noticed.
Yep.
There was, there was a lot of public interest in this to begin with. So if the individual wasn't here, didn't have the opportunity to call in and so on.
I agree. I
it
think
is
there
up
was
to the
ample
board's discretion.
opportunity, and if it's that important, they would have been here.
That's what common sense tells me, and that's what people do. Because I want this, listen, I don't have to explain what we're doing. It's unfair.
Right.
You know my reasons. We've been through the process. Everyone's had an opportunity. If Mr. Stein is not here or couldn't write a letter, that's really on him at this point.
I'm agreeing with that now. Yeah.
Yeah.
The record is closed.
Yeah.
Thank you.
Okay.
Thank you.
Record is closed, Debbie.
Yeah, otherwise it'll never end.
That's an assumption that you're completely wrong at, Debbie. Thank you.
Oh, be careful going out there. Never step down.
Interesting.
Oh, she's a jet.
She doesn't have any idea of the procedure.
Okay,
Okay.
moving
Break.
along.
Moving
Everybody else.
moving along. Right. We now are entering our post-hearing decisions work session. I'll read the first one into the record. We have Shaggy Shack LLC located at 774 Montauk Highway, Montauk, Suffolk, tax map number 300-49-4-5. The size and location is 2,681 square feet at 774 Montauk Highway, Montauk, map number 174, Fort Pond Business Section 1, Block 7, Lot 3 in Montauk. The description is an appeal of the building inspector's determinations dated September 5th, 2022 regarding the use of existing restaurant. Appellants seek to reverse the building inspector's determination that the restaurant is being operated in a manner that would change the use definition to a nightclub. Relief sought is an appeal of the building inspector's determination dated September 5th, 2022. The zoning district is CB Central Business Zone X Flood Zone, and the secret class is type 2. Who wants to begin this?
Terry.
Terry, would you like
Yeah,
to?
I'll start it.
begin?
Okay. It's past my bedtime now.
We started it 2
Uh,
weeks ago, 3 weeks ago.
Okay, this hearing was on December 6th, 2022. The agent for Shaggy Shag was John Tarbett. And as was read in, the building inspector said that Shagwong is being used as a nightclub. Okay, the appellant discussed the history of Shagwong, how it has been in existence for about 100 years, and how it's a restaurant. It's also an apartment above the restaurant, and that they have had music on occasion where they move the tables and they dance, and that has been going on forever. There were, I can't even enumerate how many people, there were affidavits that were submitted by the appellant of numerous citizens of Montauk and other places that participated in dancing over the years, going all the way back to 1947. There was much of the events they talked about were anecdotal, and there were others that were events like weddings and showers, but things that would also suffice today with the mass gathering permit. And Glennon's decision was that they would change the use to a nightclub. Part of my confusion at the hearing was that they said they don't want to be a nightclub and that they just want to keep doing what they've been doing for 100 years. So I'm not sure where that leaves them right now, but and there was much of the time period that they were talking about, there was no definitions of any of these things, including nightclub, that were in the zoning code back in 1957 and 84. And finally, in 1996, definitions for nightclub, restaurant, tavern, and a lot of other town code. It's a huge change that was made in 1996. And in that code, the additions were added to uses, the definitions for bar, tavern, nightclub, restaurant. And it was very clear the intent of the town code that was done. Let me grab these papers. So the submissions, well, let me go to Ann Glennon's submissions. They are documents that we were provided by Ann of the building permit going back to 1978 for, it was a building permit requested by James Hewitt, who was the then owner of Shagwong, and 13502. And in the application for that building permit, item number 2, he stated the existing use and occupancy of the premises. It's listed as existing use and occupancy, restaurant and home. There was some discussion as to whether there was really a home there or not, but testimony. But clearly, according to that permit, that's what it was. It was a restaurant and a home. We have a C of O back in 1996, February 8th, 1996, that states it's a two-story frame and stucco structure containing a restaurant on the first floor, 1 apartment, sleeping rooms on the second floor, et cetera, et cetera. That was for some additions that they wanted to have done. It was also, I don't have it in front of me, but there was also a zoning board, I believe, determination, because the applicant had asked to increase some space in the premises. Thank you. That was November 29th, 1978. And in that, it was clear that the request that there was a residence in this and the restaurant, and that that zoning board allowed these changes to be made so that the applicant, so that the restaurant owner, the property owner could have space for his family that he was raising there. So that's about all the documentation we have from the building inspector. On page 6 of the document that Ann and John Tarbert had attached this, there were notations in the local law that this law was being established and these definitions were being established and the use tables were being updated because it became a necessity. And it's amended reading out of that, I'm sorry, it's on page 2D. The code is amended to add definitions of bar, tavern, nightclub. At present, these items have only a dictionary meaning since no current definitions are found in the zoning code. The definitions employed here derive from the definition of bar, tavern, nightclub, which was added to the code in 1992, but with substantial changes. The definitions of bar and tavern make it clear that these uses are not interchangeable and that a bar or tavern cannot be converted or expanded into a nightclub, which is a more stringently regulated use. It also states that the changes were made because they became a necessity with the changing times. So I am upholding the building inspector's determination on this. And there are methods there. A nightclub is a special permitted use in the central business district. So if they did want to provide nightclub type services, there is a method for them to do it. And if they have a mass gathering with music and an event, that's also open to the appellant to pursue. And they could also pursue another use at that location. So my bottom line is I am upholding the building inspector's decision that they have been acting as a nightclub, but they are a restaurant and a home, a residence.
Okay, thank you. Ed?
Thank you, Mr. Chairman. I'm largely in agreement with my fellow board member. I'm going to read through something what I have here. It's going to repeat one or two things she may have said. Most of the examples cited by the appellant did not apply to the situation now in front of the ZBA. The periodic use of the tavern for individual events does not reinforce the argument in the 100-year history of the business that it was used in a way that supports the contention that there has not currently been a change of use. Even the fact that on many summer nights in the past, bands have played in the Shagwan as a regular form of entertainment where dancing has taken place does not precondition it to having been used in a similar manner as it is currently being used. The argument the Shagwan Tavern does not fit any set definition as a place of business that is partially a bar, partially a restaurant, and partially a night spot frequented by larger crowds that enjoy dancing later in the evening and late night does also not satisfy the building inspector's complaint that Shagwan is currently or was currently this summer operating as a nightclub in violation of town building codes. The reference to building code 153-1-20D adopted in 1996 clearly defines the difference between a bar or tavern and a nightclub. Shagwan Tavern has a long history of hosting parties and celebrations where dancing has taken place, and they also have a history of providing live music for the entertainment of their clientele. But neither of those typical events caused the use of Shagwan Tavern to rise to the level of being considered as being operated as a nightclub. The fact that Shagwan is a tavern and a restaurant and not strictly a nightclub does not preclude it from being considered a nightclub during the hours that it converts from restaurant use to that additional usage. There is concern that other restaurants turned to late night spots are operating as nightclubs as defined by the same code 153-1-20-D. But that doesn't change the fact that according to the provision of the code, that Shagwan is operating as a nightclub when they pull back the tables and then draw in large late night crowds. In the 1996 document, it states that the town code relative to zoning was in need of updating and improvement. In line with that thinking, under 153-1-20D, the code was expanded to include a definition for a bar or tavern versus that of a nightclub. going to repeat here slightly what was just entered by my fellow board member. The town at that time sought to make it clear that the definition of a bar or tavern and that of a nightclub are not interchangeable, and that a bar or tavern cannot be converted to a nightclub, which is more stringently regulated. They went further to state that any establishment that imposes age restrictions or cover charges is automatically as defined as a nightclub. At that time, the town recognized that a restaurant was not precluded from having occasional live entertainment or music. A special events permit 151 can be applied for to cover a given event. While the Shagwan Tavern has operated for nearly a century and has often held events that include dancing and entertainment, those occasions did not rise to the level that would allow the Shagwan, by town definition, to be considered to be a quote-unquote nightclub. So considering these facts and conditions, I find that I support Principal Building Inspector Ann Glennon's decision that Shagwan Tavern operated at night as a nightclub, which is not allowed under its current status as a bar or tavern.
Thank you. Bill?
I was leaning towards, well, let me say, the building inspector's report, while it's thorough, it doesn't address whether Shagwan is being presently substantially used as a nightclub. And I'm also concerned that I don't know if it's realistic to require them to get a permit every time they want to have if they want to have a special event like a wedding party, they could get a permit, but they did demonstrate that there's a history of dancing and music. So I guess what I'm saying is the record seems to be lacking on whether it was being substantially used as a nightclub or not. So I'm just not sure her opinion is sufficient, I guess is what I'm saying.
Thank you. I might be in the same hall with you on that. Well, let me go through my thinking process.
Well, I could elaborate a little bit.
Okay, go, please. Why? You have to go next.
Okay. I think the definitions simply don't fit. They don't address occasional dancing and live music, which which the record shows historically occurred. I mean, the building inspector suggests getting a permit, but I've been personally, as a working lawyer, assisted clients through the special permit process. And it's not that it's arduous or difficult, but it requires a lot of planning and forethought, which is fine for a wedding, but takes away from what the record evidence shows is that there was some spontaneity involved. What the record doesn't show is that the nightclub, that it currently operates substantially as a nightclub, and the definition of nightclub that they adopted in '96 said a substantial element of the establishment's business is providing live entertainment for its patrons. Well, it's not clear from the record that that's the substantial aspect of the Shagwan's business. I mean, I've been there, I've had dinner there, and I can say, at least for the time I was there, it wasn't the substantial part of the business. It was operating as a restaurant and all the tables were in place. So it may be that this summer they crossed a line, but there's not evidence in the record that shows how they crossed that line. And so it seems like she's trying to impress these definitions that were adopted after the Shagwan created this history of pushing tables back. So I'm leaning towards saying that they have a constitutionally protected pre-existing non-conforming use, but I'm troubled that the record is lacking insufficient evidence to show whether or not it actually was operating substantially as a nightclub.
Joan, there is, may I speak?
Yeah, of course. Yeah,
Okay,
I
there
think
is this ad I have here from the Montauk Sun back in 2012, after all this code was done, saying live music with 3 Bs every Saturday night.
Right.
So it's kind of it's a regular thing. It'd be more clubby.
Yeah, we can go
Yeah.
there.
The other thing you said, like pre-existing use.
Yeah.
It wasn't pre-existing. Nothing was pre-existing when they first started this. There was no use at all. So anything could be done by whomever they wanted, I guess, going
Right.
way back in time. And in 1996, the town took on this effort.
Which probably,
to define
which in my
these
mind would
uses.
support the pre-existing use.
They weren't uses.
Everything
They
was
weren't uses.
pre-existing
It wasn't
100
uses.
years
I
ago.
have
That's
to
a
say, I've
pre-existing
been
use.
struggling with
Yeah,
this.
no, I don't.
No,
Let's hear from Denise and then myself, and then I think
okay.
deliberation is important here,
Yeah.
very
Yeah.
important decision.
Yeah.
So,
It's good to go back and
Yeah.
forth.
Yeah.
This is, I spent so much time on this.
Yes.
Back and forth. Okay, so it's impossible not to repeat, so I will just do it. The building permit application for this permit, 13502, was filled out by James Hewitt, and as Terry noted, in question 2, they themselves, what is the existing use and occupancy? The reply was, restaurant and home. And in 4B of that application, same thing. Intended use and occupancy, they replied same, meaning restaurant and home. Now, section 153-120D, as stated in Ann Glennon's letter, states that a bar or tavern cannot be converted or expanded into a nightclub without getting all the necessary approvals. Now, it's not actually a code section. It's from legislative findings section of it's a section of the 1996 code recommended changes. But it's an indication at that time that things were changing and there was maybe time for the town to look at the regulatory system. Also, in the determination filed with the town clerk, a zoning board approval was given by the then zoning board to expand living quarters for Mr. Hewitt's wife and 3 children. They also received approval to expand the restaurant portion, noting they can put in a few tables, and this is from the decision, they can put in a few tables to make the restaurant a little more spacious and to install a new men and ladies room. The purpose of the expansion was connected to restaurant use, not really permission being granted for additional room for music and dancing. In essence, the determination granted modernizing the bathrooms in the tavern and modifying the apartment and expanding the restaurant portion by allowing a few more tables to make the restaurant more spacious, always with the use as a restaurant. So I'm kind of when you talk about 100 years ago, that's a stretch. 100 years ago, a lot of things were different and probably everything you could have said was a pre-existing use. But the regulatory system in a town has to deal with population, density, environment, incorporating into all of this safe and orderly growth, which they have tried to do in the town code. I'm leaning toward agreeing with the building assessor's assessment. I am in agreement with the determination made by her that based on the historic town files and documentation that Shagwan's use has always been classified as being a restaurant with a bar as an accessory. Now, the town is not saying with the changes in the code and under restaurant, I guess what I'm really trying to say too is you can't have it both ways. You can't have a restaurant and a nightclub. You have to choose. And the town isn't saying you can't. The town is saying with a special event permit, you could have a catered event. you could have musical entertainment, you could get permission for this. So that you can't really blame them for trying to control this in an orderly way. And the definition of a nightclub is an establishment primarily engaged in providing entertainment. It says nothing about also using it as a restaurant. So we can all talk about this. This was a difficult decision. And I'm interested in how you feel, Roy.
It's a difficult decision for me too. But in digging into it, if you go to the 96 code, you have two codes to consider. We have we have all of zoning to consider in this case, because this whole case pre-exists any type of zoning. But for us, it's the 96 code, which set out to put definitions on restaurant, nightclub, bar, tavern. No question in my mind that the history shows that in the application that Shagwan is a restaurant, primary use, and home. The code 96 establishes the definitions, but it also explains in the explanation of it that doesn't preclude a restaurant from dancing, or does it preclude a nightclub from serving food or water? So food or drink, right? As long as it doesn't act as the other,
primary.
right? As the
Right,
primary, as
right.
long as it doesn't act. So that's the way I'm reading it. Secondly, I agree with Member McGivern is that on the town side, the building inspector, there's lack of evidence showing, there's almost a complete lack of evidence showing that there was an issue, where on the appellate side, there's overwhelming evidence that it always existed, that dancing always existed at the Shagwan. So the question in my mind is that a pre-existing use? Obviously, in modern zoning, and in the 2000, I'll back up a little bit, in the 2007 code, it defines it a little bit further, saying that a restaurant can't clear tables, right? So it defines it even further. I don't know why they did it, but for some reason they did it. And it might be this reason, but for me, modern zoning, always, if you have a pre-existing use, you have a pre-existing use. And I think this is the case. Now, I don't think that the nightclub or the dancing part of it is a primary use. I think it's an accessory use in this case if it's pre-existing. And in no way should the Shagwan be exceeding that in the history. So I'm struggling with this myself. I'm leaning to oppose to not uphold the building inspector's determination based on that pre-existing, because it all comes down to whether it's a pre-existing use in my mind.
But see, to me.
And we can discuss this, guys.
Right. When you look at bar or tavern, it clearly says the permanent or temporary removal or relocation of tables and chairs from an establishment to permit dancing, or the establishment of an area for dancing, shall constitute the creation of a nightclub.
In modern.
In modern code. And,
Correct.
And in modern code, it talks about substantial, to Member Delene's point, on the one hand, a restaurant can have some dancing, and on the other, a nightclub can serve some food. So the question comes down to, is it a substantial element? And the code talks about substantial element, and I'm not sure here that having live music once a week is a substantial element of a business, but it does skirt the line, so.
Well, what skirts the line is trying to act tonight like nightclub, bar and tavern and restaurant are the same.
They're
That skirts
not the
the
same.
line. They're not the same.
They're not the same.
So
right.
if we're going to turn around tonight and say this use is acceptable, that's what we're saying. We're saying not only.
No, I
do
think,
you have
no,
a
I think,
restaurant,
I
we
think,
can't, we can't define.
honestly, I
We can't
uses. We
define,
can't
I
but
think,
we're
I
only
think we're
kind of
not,
agreeing
I don't
that
think
we're
we're
being a
making, I don't
nightclub
think we're
too.
making a broad stroke decision here, guys. I
Well, it
think
will
this
be.
is a unique
Oh, it will be.
situation. I think this is this is a unique situation.
Right.
And I think the uniqueness of this case goes back to the fact that it's been doing this since the beginning of time, right?
But
And
that's
so-
why codes
So
come
we have to
in.
carve that as, what's that?
That's why codes get created by the town because they see a need for something
Right,
that has gotten out of
Yeah.
hand. Why do we have NRSP codes in
Right.
1984? Because things happen,
And we
times
all, and we
change.
have many cases come before us as pre-existing non-conforming.
But there was something else in this 96 thing about structure versus use.
Now, on the other thing we have to look at though, in on this pre-existing use is was it continuous use? If, in other words, was there a period of time where it didn't exist that way? We don't know that at this point. It's hard to say that, but I think the appellate did a good job bookmarking, if you will, the fact that dancing did exist and we had affidavits and public comment supporting that it in modern times, it still exists.
You know, but in 96, they made an effort to try to clean up the code and to come up with better definitions for future reference. And in my mind, the kind of dancing and the regularity of it does not compare with the use of a nightclub, so that we have events happening in a restaurant, which are typical of lots of restaurants in many locations. And now we have what's significantly, in my mind, a change of use where you have something coming in. I will say that the word substantially was brought up by Member McGivern bothered me because I don't know how we can define whether or not what goes on after hours or late night hours at the Shagwan represents the substantial use in the price. We don't know if it grosses more income for them or less income. So there's some pause when the word substantially was used.
But it's in this definition. Substantially.
Yeah, it is.
Yeah, but what's substantial?
yeah, well, yeah, right, what's substantial?
So my point anyway with this whole, for me, from where I'm coming from, is that I see that this effort made in 96 was to try to define in a way how these two entities are different, how a bar and restaurant and a nightclub are different. And in my mind, there's a difference between what's gone on and has been anecdotally reported by the appellant in this that's happened all this time and what is currently happening there. I will say that Ann Glennon's comments were lacking in detail, but we take, I guess, on good faith that she's done the kind of investigation in order to back up writing a letter like that. But the fact that whatever's taken place at this point, what's taking place right now is at variance with what the past usage of that property or that.
But we don't have a documentary record that shows that. We just have Ann Glenn saying, well, I think one of the things that bothers me is that living in East Hampton, everybody knows that they've been trying to crack down on Montauk. But cracking down on Montauk doesn't necessarily justify taking a particular establishment that, at least based on the record evidence, shows they have a continuous history of pushing the tables aside and having live music. Now, maybe they've abused that privilege or that use, but we don't have documentation to show that. And so that's why I'm in favor of not affirming the building inspector's decision. That doesn't mean they can't come back to show that they have live music 7 nights a week. I mean, they're open 7 days a week all the time.
Not really. Okay.
Well,
Mostly.
mostly, but. So I don't think it's not a decision that comes with prejudice. It just comes with lack of evidence.
Well, I have to say, I think that the town in the 1996 findings was trying to address orderly growth, a regulatory system that would, because the town is not, to base something on what 100 years ago, that's a stretch. So I'm going to stand behind upholding the building inspector's determination.
Yeah, can I read this sentence somewhat applicable? And in that same document in 1996, page 5Y, it says the definition of a special permit use is clarified and improved. Now, of course, that wasn't a special permit use at all, wasn't a use at all. But just again, the intent here, the zoning board of appeals has construed the existing definition to not apply to a use which predates the special permit requirement in its zoning district, notwithstanding that the use would today require a special permit to be established in that zone.
That's
This
because-
interpretation is
yeah.
now overruled.
Mhm.
So they overruled that. I think that was kind of supporting what you were saying, John.
Mhm.
And then number 14 here on page 9 says deletion of non-conforming use expansion of, there was clearly subsection formerly labeled uses listed in 153-550 is reworded and improved and added uses listed is currently found, blah, blah, blah. Provision in question makes the specific standard safer for special permit uses applicable to those uses even when a special permit is not required. I don't quite get that, but I don't know. To me, there's a whole lot here about uses, dividing up code between structures, pre-existing structures, because there was a statement in here, I just can't find it right now, that stated that structures are easy to quantify.
Right,
Where
and
these
uses
uses,
aren't.
as we're finding out right now, are not so easily
Right.
quantified. So they were trying to clean that up and separate
Yeah.
those, this pre-existing stuff from each other.
And the applicants in their own paperwork have always referred to themselves as a restaurant
The appellate.
and,
Yeah.
and home. Yeah, the appellant. And home. So even they themselves are looking at themselves as a restaurant / bar residence.
Okay, so where are we?
So
I'm upholding, I'm still upholding.
Ann Flannan's interpretation.
And I'm going to oppose it, but I'm going to say that, I think there's, in my mind, there's some credence with the, when you have a police chief, you have Paul Monty, who's from Montauk and very involved in gurneys and stuff like that. And so that to me is kind of compelling evidence too, that it's an accessory use. So I believe it's accessory use. I think it's accessory use, which is subordinate to a restaurant, not the main. But go ahead, Ed, I'll let you.
No, I'm gonna stay with, I've thought this through and I'm gonna stay with what I've said, because I do think that there is a difference in what these two, by definition. And I found that the work that was done in 96 to be compelling, and I agree that there are gray areas here on this particular case, though. I'm comfortable in sticking with my decision.
Thank you.
And I'm with Member Deline. Besides record evidence issues, which I have, I think at least on the appellant side, they've put in a good record that they have a pre-existing non-conforming use. And I'm not sure that the building inspector has put in record evidence on this particular establishment, not all Montauk establishments, on this particular establishment, that it's operating as a nightclub. So I'm opposed to the.
Thank you. You okay, counsel?
Yep.
All right, move on. Okay, next we have Wickapog Realty. That?
It's nice tonight.
Groans.
Something wrong again, Terry.
I must
doing
have
great.
done something evil, I don't know.
We have Wickapog Realty 1 LLC at 391 East Lake Drive in Montauk, Suffolk tax map number 300-7-3-5. The size and location is 73,269 square feet total. includes underwater land at 395 East Lake Drive, map 6595, map of Indian Rills, lot number 5, and described property in Montauk. The description is to demolish an existing residence and to construct an approximately 5,649 square foot, two-story residence, including attached garage, swimming pool, decking, and sanitary system on a parcel containing tidal wetlands and surface waters. The relief sought is a natural resources special permit pursuant to 255-420 of the town code and any other relief necessary. The closest structure and sanitary system have been proposed 101 feet and 232 feet respectively from a wetland boundary. Zoning district is A residence, AE flood zone, elevation 5 and 6, and X flood zone, and the secret class is type. Who's?
Excuse me.
Yeah, go ahead. Go for it.
Thank you, Chair. Okay, this hearing, I gotta do these earlier in the night. This hearing was on November 29th, 2022. Kapog Realty. The agent for this was Bruce Anderson. The application was to demolish an existing structure and rebuild a two-story structure. The requirement is for an NRSP. There was a lot of discussion, as I know some of you were on, and back in 2019, there was an application to demolish the existing structure that exists today that came in front of this board. And there was an approval done for the reconstruction of that property at that time. And that too, I believe, was for an NRSP. Ownership changed along the way, and this application came in substantially, what I feel is substantially larger than the application that was approved back in 2019. Numbers somewhere. Yeah, back in 2019. So the approval was given back then. This project, as I see it, well, let me back up a little bit. There was some new submissions that were sent to us, which we received on January 3rd of 2023. There was a new survey. That survey changed some of the total lot coverage numbers and lot coverage, basically about the lot coverage a little bit. And there was a septic from Suffolk. We got this from Suffolk Environmental Consulting, Inc. The revised survey, an engineered septic plan that was not included in the original application for it. That was dated January 5th of 2022. Native revegetation restoration plan prepared on December 20th, 2022, and architectural plans updated and prepared by Ryan Kestner, dated December 27th, 2022. In that notice, they disclosed a reduction in coverage. They talk about percentages, which I don't really care to do. It's 18% of lot area and some reduced building coverage, reduction of 11.9% for a dwelling that features 4946 square feet of gross floor area. It also notified, because it was required, there was a large stone revetment, small stone revetment along the shoreline here. And they notified that they undertook the removal of some of the large stones in January of this year. He said he attaches an invoice that I don't think I ever saw. I don't think it was attached. But I was there today, and they definitely, looking at the photos that Brian Frank originally showed us, and that clearly there were some stones removed. There's probably some more work that the planning
I think the small
department would
stones are
want it
still
done.
there, yeah.
Yeah, there's still some, and there's some other debris there, some concrete pieces, and I thought I saw some wood pieces, but they did do some work. But, okay, now, this property is part of Indian Rills subdivision. And back in 1979 was when that subdivision was created. Back in 1979, I believe, is when the first C of O
was granted on this particular property for the current house, that there's for the current house. So looking at this application,
I believe the subdivision was 1977.
77?
Right, just to clarify
I was
that.
just looking
Okay.
up the same
Yeah, I
thing.
have that here.
So maybe that's the first C of O was 79.
What?
Yeah, the first C of O might have been 79, but the
Yeah,
subdivision was
that's
77.
true. That's true. I'm sorry. I have.
That's
the
okay.
sub, thank you.
I just had that written down, so I
Yeah.
remembered writing that.
So, yeah, July 13th, 1977.
Mhm.
And on that, in that subdivision document that was also in our file, number 5 says there shall be a minimum setback of 20 feet from all scenic easement and reserved areas. This project, I think, has gone beyond something that was acceptable in 2019 with the size and the structures. I keep losing my paper. Back in 2019, what this board approved was a lot coverage of 2,956 feet. And today, the application is looking for 4,852 feet. The total lot coverage in 2019 was 4,951 feet. And in today's application, it is 7,951 feet. I feel that this application does not, well, first off, the scenic easement, the geomats on the survey, the latest survey, show that the geomats are going to be placed 7.7 feet from the scenic easement. I believe it's north on the East Lake Drive side. And, yeah, it looks like north, which does not conform to either regular scenic easement, setbacks, nor, and certainly not from minimum setback of 20 feet from the Indian Rill subdivision document. Right there, aside from that, with the total lot coverage and the lot coverage in general, that this also is too much. It does not conform to the existing town code in 255-111, then orderly growth and protection of neighborhoods. I think this application, this structure would change the character of the neighborhood. We saw, over aerial views of the other properties in the subdivision. Bless you.
Thank you.
And I think this would change the whole character of the neighborhood. This is a portion of East Lake Drive down where most of there are not many structures, but what is mostly there is natural habitat. It's adjacent to town parkland. It's across the street from county parkland, and it's adjacent to town reserved area, park area, where there's shellfishing done. And part of the problem with this, it is just entirely too much put onto this property. So I think it does not meet the purposes of zoning in orderly growth and development and redevelopment in accordance with the comprehensive plan, the protection of neighborhoods, and preservation, preservation of protective barrier dunes and beaches, productive wetlands, animal habitats, and other natural resources. This is also in an H-pod area. Clearing was an issue too, but the applicant did say they would bring clearing into conformity if this were to be approved. Also doesn't meet the 250 special permit uses standards of 255, 551. The natural resource permit, again, D, preservation of natural resources. And there are some alternative uses of the property that could be done, alternative designs, particularly number 2, alternative designs entailing smaller buildings or structure, reduced yard or other setbacks, or diminished or reconfigured areas. The Lake Montauk is also in a statewide area of scenic significance. It's in the H-Pod overlay district. It's in the Peconic Estuary, whatever they call that.
Critical environment.
Critical environment. Thank you. And so for all these reasons, I'm looking to deny the natural resources special permit for this application. And I think that the scenic easement, they need to conform to the scenic easement to the setbacks that are included in the Indian Rill subdivision that was established by the planning board back in 1977.
Thank you, Terry. Ed?
Okay, I'm not going to repeat a lot of the information that fellow board member Berger introduced, particularly about her reaction to how it fits into the code, but I do have a few comments. It's important to know that where this property is located, it's immediately north of the outlet of Little Reed Pond, Lake Montauk, an environmentally sensitive area. It's a lakefront parcel with slightly more than 87 feet of water frontage on the lake. The parcel is encumbered with 2 scenic easements, one to the northeast end of the property along the East Lake Drive, and a second along the southwest end of the property along the shore with the lake. Property was in front of this board in 2019 and received a approval for a smaller project than the one in the current application. The current proposal increases the size of the project significantly, both in building size and in total lot coverage. And the submission that was dated from the applicant of December 30th, 2022, and received on January 3rd, 2023, the applicant attempted to answer some of the concerns raised at the public hearing. The building square footage minus the garage was reduced from 4,815 square feet to 4,512 square feet, where the existing structure is 2,370 square feet. And the total lot coverage was reduced from 7,893 square feet to 7,096 square feet, where the existing is 3,735 square feet. A sanitary system plan, an updated survey, a planting plan, and revised building plans were also included in the December 30th submission. One of the primary issues raised in the hearing was that of the Indian Rill subdivision approval to call for all structures to be set no closer than 20 feet from scenic easements and required setbacks. The 2019 ZBA approval cited that the plan submitted at that time honored that requirement. Major concern related to those required setbacks is that if observed, they would help to allow demolition work, construction of new structures, and the installation of the IA sanitary system to take place without causing collateral damage to protected areas. The current application does not honor that requirement, and in suggesting a larger residence than the one approved in 2019, with structures encroaching on the 20-foot setback requirement, that there is a greater danger inherent with moving forward with a project of this size, and that damage would be done environmentally to areas previously protected by the action of the town and its involved boards. 2019 decision by this board carefully considered the impact that a redevelopment on this site might have on the environmentally sensitive parcel and ruled that the 20-foot setbacks be observed and that the scale of development be limited. I am in agreement with that thinking. I think that the scale of this currently proposed project is not in keeping with the best interests of the parcel itself and the intent of town code in protecting the character of the neighborhood that it represents, and the overdevelopment of the site is not being, and the fact that the site has been proposed to be overdeveloped is not worthy of being granted an NRSP, according to code 255-4-20 pursuant to code. This parcel was granted approval for a significant upgrade in the residence and its appurtenances in the recent 2019 CBA ruling that represented a significant expansion of existing residence. I believe that ruling established the limit of the development that this parcel can bear, and that this application, if granted, would allow for far more expansion, a far greater expansion that agreement that could possibly be allowed. So I am looking to deny this application.
Thank you. Denise?
Thank you. A lot of what's been said, I won't repeat. I too, in order to be eligible for an NRSP, the project must be compatible with 255-111, the purposes of zoning, and satisfy criteria set forth in 255-540 and 255-551. It was already been noted about the geomat leaching system of the septic system has been proposed like 7.7 feet from the scenic easement. 1977 Planning Board resolution established the subdivision required a 20-foot setback from all scenic easements and reserved areas. I think the project as proposed cannot be expected to properly mitigate the constraints on the property. This area of East Lake Drive's shoreline is characterized by low elevation primary dunes vegetated with beach grass. And it should also be noted that this particular shoreline at Lake Montauk is a high energy shoreline. As Member Berger stated in her very complete analysis and summarization of this, the Lake Montauk is a New York State significant fish and wildlife habitat and a component of the Peconic Estuary Critical Environment Area. This is in an HPOD Zone 2 and is also located in the scenic areas of statewide significance. I think the nature of the proposed use is not in harmony with or will promote the general purposes of zoning described in 255-111. I don't feel the project can be completed without causing a detriment to Lake Montauk. The project as proposed will cause undue disturbance to important natural features. Finally, in the previous board's determination filed July 17th, 2019, I was not on the board at the time, but the board did grant an NRSP for a 4,300 square foot residence, a swimming pool, decking, detached garage, and septic system. There was on the property at that time a small stone revetment established along the shoreline. It was noted on the survey as a rock pile. One of the conditions of approval was removal of that. I did not see a receipt for the removal of the large stones, but apparently they have been removed. But I think that the small stones still remain. I think the project, for these reasons I've already stated, should be denied. The project needs to be reduced in scale because it actually increases the building coverage by approximately, I think, about 64%. The project as proposed is not in keeping with the purposes of zoning and does not meet the threshold for the grant of a natural resource special permit.
Thank you. Joe?
Whew, I think I'm in complete agreement with my fellow board members, and I'm not sure I have much to add. I should disclose that I'm somewhat prejudiced because I was part of the July 2019 decision, and I thought that was a reasonable proposal, and but on the other hand, it sort of tested the limits of what you could do with this property. And it illustrates that you can do something with this property that isn't quite as aggressive. I don't really have much to add. You've covered everything.
Well said. Well said, everybody. I agree. I think that in this particular property, not only the property, but the area, you can't underscore enough the environmental sensitivity that we have here. And it's been outlined in the TIM. It's been outlined by each one of you board members. And I think for the very reason you have the easements, those are the reasons the easements were established is to protect those natural resources. So it'd be inconceivable to think that the subdivision at that time would allow a septic system to be allowed within the 20 feet. I think it was intended to be 20 feet all inclusive. And so I think that the fact, just on that basis alone, I think this application fails. And based on the NRSP standards as well.
I think that when we have the establishment in 77 of the Indian Rills subdivision with clearly stated 20-foot setback, and then the decision rendered by this board in 2019, which honored that.
Strengthens it.
Strengthened it because it reaffirmed that it believed that it was necessary.
Mhm.
And then I think what I had said was, I think that what was established in 2019, and again, I was not on the board at the time, what was established there was the limits of expansion that could be tolerated in a situation like this. I think that to me spoke volumes about what we should be looking at in terms of this and examining it on our own. But this is too large a project with too many negatives involved.
Thank you.
You good?
On to other decisions. We have revocable trust of Robert E. Isaacson, 233 Gerard Drive in Springs, Suffolk tax map number 300-42-2-9, and that's requesting to reopen the record for the submission of a construction protocol and foundation plan. Do I have a motion to open the record?
Yes, from what I understand though, which is what I was thinking about, we have received a construction protocol and foundation plan, correct, Laura? Okay. So I'd like to make a motion to reopen the written record for the submission of a construction protocol and foundation plan. With regards, I'm sorry, with regards to revocable trust of Isaacson, 233 Gerard Drive, Springs, Suffolk County Tax Map number 300-42-2-9.
Second.
Concur.
I'll concur.
I concur as well.
Now we have to close, correct?
Yes, we have to close.
Yes. So we
Okay,
accept
I'd
them.
like to make a motion to close the written record for, with regard to revocable trust of Robert E. Isaacson, 233 Gerard Drive, Springs, Suffolk County Tax Map number 300-42-2-9.
Second.
I concur.
I concur as well. Thank you. Next, we have extensions of time, and that's Eshagian and G-Biz LLC, 9 and 15 Bruce Lane Springs, Suffolk tax map number 300-57-2-16.1 and 16.2. Morgan, who's got a brief, that's an extension of time.
Morgan? Morgan?
What is it for?
Just brief, just tell us when it was and what's it for.
So originally it was actually submitted as a modification because this is a decision from 1972.
Oh.
And I think the applicants thought that they needed to modify the conditions of timing on it, but I discussed it with council. I think you can handle it as an extension of time. That being said, this was a two-lot lot area variance. It was a property that was divided into two lots. It has one lot had at the time two cottages on it, and basically the decision was, we'll grant you the division. You can combine the two cottages into one unit, or you can remove one and then build a residence on the other lot. That hasn't happened in all these years, which is somewhat surprising given our real estate economy. But basically, the situation is exactly the same. The zoning's the same. The lots are
Was
still
there any
there.
conditions on it at the time? Like if you didn't act on a certain time, it would revert or?
No. Yeah,
No?
and that's the thing. It was open-ended. So, and the situation is still the same. Zoning's still the same. So,
And there's no natural resources or
Nope.
anything like that? Okay.
Nothing has changed in that whole environment in 72, this is 72?
basically, the site conditions are exactly the same. I mean, there've been some building permits to do some changes to the cottages, but you still have two cottages right side by side, and then the other lot is vacant. And in that memorandum that I provided you, I also attached the building record card, and the second lot can't be built on until one of those situations occurs. And our building record card still notices that second lot is an unbuildable lot until they conform to your conditions. So
That's right. It was
remarkably in 50
there was one
years.
similar we had
They don't
a
need a
year or
whole
two
new
ago on Bruce
application?
Lane. I think there was one similar. to
Where
that
is Bruce Lane?
at Springs.
Well, that I know,
It's-
but
It's like just south of
Yeah.
Camp Blue Bay.
Yeah.
You made some.
So, okay.
So we have no objection to you guys doing it as an extension.
really,
Do I have a
I'll make a
motion?
motion in the matter of the application of Eshagan and Jabiz LLC, 9 and 15 Bruce Lane Springs, Suffolk County Tax Map Number 300-57-2-16.1 and 16.2. I make a motion that we approve the extension of time.
Second.
I concur.
I think I concur.
I concur as
You're
well.
not sure?
1972.
I know, but there doesn't
Yeah.
appear to be any environmental changes. You want to put a time limit on it now?
Another 50 years?
No.
You want to put another 50 years on it?
I mean, the condition is an appropriate condition to have on the site. You know, you don't want, change. You can't build on the other side.
Right.
unless-
Yeah.
so It's not.
Okay,
gonna
that's why
change.
it's not like a wetland
change.
involved or.
Okay.
We have draft minutes of 17th and 24th.
Oh, I make a motion to approve the minutes for the East Hampton Town Zoning Board of Appeals for January 17th, 2023.
Second.
Concur.
I concur.
And I concur.
And I make a motion to approve the minutes for the East Hampton Town Zoning Board of Appeals for January 24th, 2023.
Second.
I concur.
I concur. Thank you. Next, we have three resolutions. We have care of Britton, Vestrian, Montauk Sunset Cottages LLC at 3141 East Lake Drive in Montauk, Suffolk Tax Map number 300-20-2-13.1 and 13.2.
Okay.
This application was to demolish all the existing improvements, reconstruct 10 resort building cottages, relocating 4 of them to construct a new approximately 6,700 square foot 2-story residence, 2 sanitary systems, a 16 by 56 swimming pool, accessory buildings, grass paper parking stalls, and the establishment of a grass vehicular path on the shoreline of the land. A natural resource special permit was requested along with some variances from the minimum wetland setbacks and coastal setbacks. Overall, the board did find that this application was, had no objection to the minor setback reductions to the shoreline. The application supports increasing the setbacks to the freshwater wetlands north of the property, and in doing so, it was providing protection for the preservation of these vital wetlands. The project has increased the distance of many structures away from the freshwater wetlands and have moved them to a more conforming place within the property. The applicant's committed to restoring the beauty of the subject parcel, and the new construction essentially being built in kind to what exists on the property currently. As such, there will be no additional use beyond the current use that exists. Overall, the project appears to be an improvement to the existing conditions on the property. The applicant has submitted a very extensive revegetation plan, and many of the structures are moving away from the wetlands, thus maintaining the character of the neighborhood, increasing buffers to the wetlands. All roof structures shall be furnished with gutters and leaders as such as required by the town code, and we are getting a new, 2 new septic wastewater treatment systems. The board overall voted in favor of the application, all in favor. I did want to point out that there are 2 additional conditions that the applicant wasn't aware of that we added during the decision process. One was that this approval shall be conditioned on receiving the negative declaration from the planning board, as that seems to be still pending, although we don't anticipate there being a positive deck at all in this matter. But it will be dependent on that. And also that the applicant must submit updated floor plans and elevation plans for the cottages being relocated as shown on the approved plans prior to the issuance of the building permit.
Very good.
Oh, okay. That's me. So for the matter of Vestrian, Montauk Sunset Cottages LLC, 31 and 41 East Lake Drive, Montauk, tax map 300-020-02-13.1 and 13.2. Make a motion to approve the resolution as written.
Second.
Concur.
Abstain.
Oh, that's right. I concur as well. Thank you. Next, we have 175 Atlantic Avenue LLC at 175 Atlantic Avenue, Amagansett, Suffolk tax map number 300-178-2-3.
The purpose of this application was to demolish an existing residence and accessory structures and to construct a new approximately 3,200 square foot residence with a 550 square foot storage area, a 400 foot 50 square foot swimming pool, 808 square foot pool patio, new sanitary system, approximately 1,100 square foot of driveway, 380 square foot covered parking area, first and second story decking and walkways. It required a natural resource special permit. No variances were required for this. This property has appeared before the zoning board of appeals previously in 2018 and 2019 and was denied for an application for a new residence with associated structures. In 2019, the applicant submitted an application for a similar in nature for the construction of a similar application for the same exact residence and accessory structures. This application was denied by the zoning board on January 31st, 2019, and it shall be incorporated, that decision shall be incorporated within this decision. The subject parcel is located within the East Hampton scenic area of statewide significance, which discourages the alteration of dune habitat, and natural terrain for residential house sites. It notes the importance of maintaining native plants to retain the visual character of the area. Here, the board finds that the gross floor area of the residence proposed to be reduced from their original application from 3,700 square feet to 3,200 square feet, with 550 square feet of storage area. This results in the same approximately 3,700 square foot building that was proposed previously. And while a portion of the habitable space was removed and limited to storage, this does not take into consideration the board's concern about the mass of the building and its effects on the natural characteristics and beauty of the natural dune. The applicant's current application before this board requires approximately half of the subject premises to be cleared during construction in order to construct the proposed structures. This clearing also requires clearing for a pool and 800 square foot of pool decking. And when the project is taken in its totality, this is a massive rebuild and relocation of the property, causing large amounts of disturbance to the natural terrain. The entire parcel is covered in rich dune lands with vast vegetation. Retaining these dune lands is the best method of conservation, and the proposed final clearing is double the existing clearing as represented today. The plant communities present on this parcel have become less common throughout the Long Island and entire Mid-Atlantic region, and the difficulty to restore those communities is difficult to reestablish after construction. The applicant did not consider adequate buffers to mitigate the impact of human disturbance. The immense amount of clearing on the property takes away most, if not all, adequate buffer yards, and appropriate screening cannot be provided to the parcel to ensure that the same quality of dune lands by the applicant's removal of rich lands. The only significant improvement in the environmental conditions is the installation of the low nitrogen IA sanitary system, which is a requirement in a redevelopment and should be utilized to further mitigate appropriate levels. The board has suggested in the previous determination to reduce the amount of overall clearing. The most effective measure to preserve the natural characteristics of the subject premises is to limit the clearing and regarding regrading to the smallest area practical. The subject parcel will have massive amounts of disturbance to its natural features of approximately 11,596 square feet during the construction phase. This amounts to a clearing of approximately about 2.5 NBA basketball courts. It is clear from evidence presented that the entire parcel is rich in dune lands and vegetation. The amount of disturbance to the parcel for construction is extreme. The lack of the ability to revegetate with the same quality of vegetation needed, and the disruption of the parcel as a whole, the massive residence and the accessory structures limit the applicant's ability to protect the dune lands. As such, the board, overall, the entire board denied the relief of this application.
Thank you. In the matter of 175 Atlantic Avenue LLC, located at 175 Atlantic Avenue, Amagansett, Suffolk County Tax Map Number 300-178-02-03, I make a motion to accept the resolution as written.
I'll second it.
I concur.
I concur as well. Next, we have Daniel Borm at 14 Ocean View Terrace in Montauk, Suffolk Tax Map number 300-49-6-24.
Just to refresh the board's recollection, this was a application that was done without a public hearing. It was an administrative application we sent through without a public hearing, and it was allowed an existing hot tub spa to remain located within the side yard setbacks. A side yard variance of 1.8 feet was requested for the hot tub spa to remain in its current location. In February of 2021, the applicant applied for a building permit to build the 512 square foot swimming pool with drywall. And later in 2021, the applicant applied for another building permit for the deck and the hot tub in June. The board finds that granting the requested variance will not cause an undesirable change to the character of the neighborhood or create a detriment to nearby properties. The subject hot tub spa is protected from outside views by fencing and existing vegetation. The variance requested is de minimis in nature at only 1.8 feet where a 20 feet setback is required. And there's no negative impacts on the environment is expected from the location of the hot tub spa. As such, the board did grant the relief of the variance of 1.8 feet with all being in favor.
Thank you.
Okay, so in the matter of Daniel Borum, 14 Ocean View Terrace, Montauk, tax map 300-049-06-24. Make a motion to approve the resolution as written.
Second. Concur.
I concur.
I concur too. Thank you. I think that concludes our evening.
Then I would like to make a motion to close the public hearing and work session of the East Hampton Town Zoning Board of Appeals at 9:19 PM. Oh, for the date, hold on, for February 7th, 2023 at 9:19 PM.
Second.
Concur.
I concur.
I concur. Thank you.